May I please?
Yes.
My Lord, may I pray for listing an unlisted writ appeal for today for withdrawal?
Can you get it before? There are not much matters. You can get it. Immediately.
May I please, Your Lordship?
Yes.
Lordship, item number 6, Lordship. Here, Lordship, there was specific direction to file additional affidavit. Specific
By the
direction
state.
was given to me. I have not filed yet, Lordship.
By the state.
But
Yes, Lordship. Order dated 31/5/2023, Lordship.
Let us see the file.
I have received the instructions, but then these are not, Lordship, proper. I need more,
Let us see the file. Let us just.
Lordship.
item number 6, sir. Oh. That bifurcation of the village.
Yes, Lordship.
What is left here? My Lord Justice Medhizor.
Yes.
Yes.
What is left here? Everything has been taken care of. And what only thing the Gaupura's right is thought to be established here. What right does he have? It's a policy decision of the government. Mr. Panning, you are appearing for? What about it?
Nothing is there.
The bifurcation has taken place?
Yes.
You are
Already,
continuing?
already.
Okay, sir. Then he comes and challenges. There are many challenges. Finally, this court says what right government is. And he also he's only wrong. He says my right is wrong. So this court has interfered. The only time taken was the consent of Israel. Consent of the Gampura was there. Simply Gampura is doing more than the Gampura. That's all the decision.
Do you have any rules for recognition of a village?
Only on that I have been asked to file, Lordship. We have already stated in our affidavit, earlier affidavit also in the WPC, there is no guideline as such, but then we have some criteria which we follow while establishing new village, Lordship.
Okay. In terms of the order dated 27/7/2023, passed by this court. Another 2 weeks' time is granted to the learned government advocate to file the affidavit. Listed accordingly.
Matter is pending from 2019. You just get that on record.
Lordship. Obliged.
My Lord. Your Lordship, there was a delay which has been condoned by this honorable court, and the victim side is also appearing. Today, the matter is fixed for admission, Your Lordship.
My Lord, IS 66 for the suspensions of the conviction with IS 66 is pending. So, Lord, next that may be hearing for the IA for suspension of conviction, IS 66.
Your Lordship, this appeal has to be admitted first, then only Your Lordship.
Sorry.
Can call for the records, there are. POCSO first.
My lord,
From which court?
From the.
LCR report not yet kept, maybe called LCR.
Mr. So-and-so, learned counsel for the appellant, and Mr.
Here, the additional PP, your body
So-and-so,
state.
learned additional PP for the state, and Mr. So-and-so, for the victim. Learned counsel for the victim.
Page 85. District and special judge. POCSO for the district of East Coast.
Admit the appeal. All for the records of POCSO case number 11/2022 in connection with SIPA West PS SIPA WPS case number 12/2022 from the court of the Learned District and Session Judge POCSO. Special Judge. Learned District and Special POCSO
For the district of. Is coming, yes, coming and top.
is coming, West coming, and Tawang at Bomdila, Arunachal Pradesh. Listed after the receipt of the records.
After Your Lordship, 4 weeks, Your Lordship. Record has
My
to
lord,
come
After the record.
That's what-
after the record, receive of the record. Okay.
That's what it is.
Yes, I will calculate after the receipt of-
Sir, we will not pass any order.
Yes, ma'am. Deeply obliged.
I don't know about board.
May your Lordship. Lordship, here conducting counsel, Mr. Naveen Kumar is outstate counsel from Delhi. And I have been instructed to fix this matter on 8th of April,
8 of.
Delhi,
8 of,
April,
I think.
and the consent has been taken.
We cannot give you that indulgence. 8 April.
I have just instructed by.
We look at the 3 weeks. So. Mr. So-and-so. Learned counsel. Makes a mention on behalf of Mr.
Naveen Kumar,
So-and-so, the learned counsel for the
petitioner.
petitioner. And 6 adjournment of the case. On,
Very good.
8th of April.
Central.
for the case on,
Yes, sir.
on.
8th of April.
8 of April.
On 8 April, 2022. This court. We are however not inclined to grant such long adjournment. We accordingly fix the case after 2 weeks.
Sir.
Also heard Mr. S. Tapin, learned government advocate, learned senior government advocate for the state respondents, and Mr. So-and-so, learned counsel on behalf of Mr. M. Kato, learned DSGI.
Central government. The challenges to the central government. They have not filed their affidavits. So in the meantime, they can also file. You file your pleadings.
In the meantime, parties may exchange their pleadings.
Because
Right.
it's you who is to take a stand.
SIPA. This is a appeal on behalf of the state government lordship. Here lordship, the read petitioner lordship, who is the lordship, assistant mineral development officer lordship. He wanted to lordship contest the election and then he put his resignation lordship. Since lordship for the purpose of resignation lordship, to consider the resignation, the vigilance clearance from the vigilance department and NOC from the deputy commission
that the encroachment, land encroachment or the encroachment on the public property is not their lordship. These two clearances are required, lordship. What happened here, lordship? The deputy commissioner, the NOC was granted by the deputy commissioner. In the meantime, it was cancelled, lordship. And the writ petitioner approached this honorable court, lordship, and it was subjudiced before this honorable court, lordship. So, on such under such circumstances, lordship, the resignations placed by the petitioner could not be considered. In the meantime, lordship, ultimately, that writ petition was lordship, disposed of with the direction to the deputy commissioner to hear the parties and to pass an appropriate order, lordship. And when this very process was pending before the deputy commissioner, the present writ petition was filed before this honorable court, lordship. With a prayer, lordship, his resignation may be, lordship, deemed, lordship, resigned from the date when it was placed before the authority, lordship. So on that very writ petition, lordship, the present impugned order has been passed, lordship. Impugned order is at page, lordship, page 11, lordship. It starts from page 11. And relevant is at page 13, lordship.
Page?
Sorry, para 13, lordship. Page 16.
Page
Page 16, 16, lordship.
16.
Oh, lordship. The Honorable Supreme Court, in the case of Dinesh Chandra Sangma versus so and so, reported in so and so, has held in the
You're reading from para 13?
para 13, lordship.
Okay. Read.
Held in context of voluntary retirement under Fundamental Rules 56C, has held that non-acceptance of such proposal within the stipulated period would amount to deemed acceptance on the expiry of the said period, laws. In the instant case, it is not a dispute that the letter of resignation was issued on 8/9/2023, and more than 90 days is over. There is no specific rejections of the asset offer of resignation, and this court had noticed that there is no embargo put by this court to act upon the said resignations offer. This court had also noticed that the submissions of the petitioner that there is no disciplinary proceeding against him and he was not holding any sensitive post are not denied by the respondent. As regards the allegations of encroachment of government land, this court is of the opinion that even if there is no employer and employee relationship, the authorities would have all the rights to initiate appropriate proceeding under Arunachal Pradesh Public Premises Evictions of Unauthorized Occupants Act 2020. Having come to a finding that the offer of the petitioner for resignation is deemed to be accepted, the question would arise as from which date such resignation is to be given effect. The offer of resignations by the petitioner did not stipulate any future date from which such resignation was to be given effect. The law is well settled in this regard by the decisions mentioned above, that in the event the employee does not stipulate any future date for giving effect to such resignation, the employer may not have the discretion to have another date. As mentioned above, there is no express denial of the request for the resignation. In that view of the matter, the deemed acceptance which have been held as above would take effect from the date of communications of the resignation, that is on 8/9/2023, lordship. Here, lordship, on 8/9/2023, lordship, the resignation was placed before the authority, laws. The Lanet single bench laws held that, laws. This would be held deemed accepted, lordship, from very that day, lordship. Now, what's wrong with this, lordship? So far, resignation is concerned, lordship, it is governed by the service rules of that particular employee, lordship. That's the judgment of the Honorable Supreme Court, lordship. Here also, lordship, so far this Dinesh Chandra Sangma case is concerned, lordship. That is in connection to the voluntary retirement law, under which, lordship, Voluntary retirement can be lordship taken by serving 90 days notice lordship. By serving notice lordship, unilateral resignation can be taken.
You mean to say that this FR 56C relates to voluntary retirement
Voluntary
and
retirement,
not resignation?
not the resignation lordship. At the same time, lordship, so far this fundamental rules 56C is concerned, that was already amended long time back, lordship. Dinesh Chandra Sangma's case, lordship, this is the decisions of 1997 for SCC. And after that, lordship, this very fundamental rules 56C has been omitted. Now it's not.
Why is the authority not acting on the resignation letter? What is the reason?
Lordship, this what lordship I have submitted, lordship. Because vigilance clearance are required to be lordship placed before the competent authority, the accepting authority, lordship. And as I submitted, lordship, the partly lordship matter was sub judice before this honorable court, lordship. Now, what I'm trying to submit is, lordship, this honorable court has to see, lordship, to ensure that, lordship, the resignation has been, the process has been done as per the government governing rules, lordship.
What is the rules?
Rules, lordship, then kindly come to the rules, lordship. Kindly come to page 55, lordship, 55.
This is Government of India, Bharat Sarkar, Ministry of
Was
Personal.
this adopted by you?
Yes, yes, because CCS rules, we don't have our own service rules. CCS rules is applicable to our state lordship, and we are following the CCS rules and connected lordship instruction issued by the central government.
This is 1988.
88 lordship. Lordship, this resignation from the service procedure in respect of so and so lordship. Then lordship, just I'd like to read lordship, some portion lordship relevant also. The undersigned is directed to state that instructions have been issued from time to time on above subject. Those instructions have now been consolidated for facility of reference and guidance of all the ministry, department of government of India. Resignation is an intimation in writing sent to the competent authority by incumbent of a post of his intentions or proposal to resign the office oblique post either immediately or from the future specified date. A resignation has to be clear and unconditional. It is not in the interest of the government to retain an unwilling government servant in service. The general rule, therefore, is that a resignation of a government servant from service should be accepted except in the circumstances. One, lordship, where the government servant concerned is engaged on work of importance and it would take time to make alternative arrangement for filling the post. The resignation should not be accepted straightway, but only when alternative arrangement for filling the post have been made. These are the relevant. Here, lordship, it says, lordship, the resignation has to be accepted by the authority, lordship. That's the one thing, lordship. Then kindly come to next page, lordship. 3, lordship. Next page.
This 2 is also not relevant.
2 is not relevant.
Not relevant. This is
Because
regarding
when it's
petition.
under suspension or some proceeding.
Then
Kindly come to the 3, lordship. Next page, lordship, 3. A resignation becomes effective when it is accepted and the government servant is relieved from his duties, lordship. If a government servant who has submitted a resignation sends an intimation in writing to the appointing authority, withdrawing with the latter party is the withdrawal, lordship. Until unless that is accepted, the employee can withdraw his resignation letter, lordship.
automatically.
Yeah.
Please read down. Read
Lordship,
down.
If a government servant who had submitted a resignation sends an intimation in writing to the appointing authority, withdrawing his earlier letter of resignation before its acceptance by the appointing authority, the resignation will be deemed have been automatically withdrawn, and there is no questions of accepting the resignation. In case, however, the resignation had been accepted by the appointing authority and the government servant is to be relieved from the future date, if any request for withdrawing the resignation is made by the government servant before before he is actually relieved of his duties, the normal principle should be allow the request of the government servant to withdraw the resignation. If, however, the request of the withdrawal is to be refused, the grounds for rejections of the request should be duly recorded by the appointing authority and suitably intimated to the government servant concerned.
Yes, read this 4 line again. If,
If
yes,
if any request for withdrawal,
no, if however,
if however,
ah,
the request for withdrawal, it's about the withdrawal laws.
is to be refused.
Refused.
Yes, kindly.
Refused is to be refused. The grounds for the rejections of the request should be duly recorded by the appointing authority and suitably intimated to the government servant concerned. Suppose say you want to withdraw lawsuit, but withdrawal is not accepted, then that ground has to be given by the competent authority. It's about the withdrawal of the lawsuit, resignation laws. Here, lawsuit, what I'm trying to point out is lawsuit. The so-called resignation is concerned lawsuit. This is a bilateral or unilateral lawsuit. Two, in lawsuit, unilateral lawsuit, the employee has right to resign and that need not to be accepted lawsuit. But when it's bilateral lawsuit, as in the present case lawsuit, it has to be accepted. And until unless that is accepted lawsuit, resignation process is not completed lawsuit. Then kindly come to lawsuit next, the guidelines lawsuit, rules lawsuit, page 60, Annex 6 lawsuit.
Page 60.
Page 60. Acceptance of resignation procedure.
No, from this office memorandum, you have not been able to show anything substantial.
Lawsuit, it needs to be accepted.
It needs to be accepted. Why have you not accepted? Because actually the ground of refusal has to be communicated in order to reject.
No, not that lawsuit.
No, because
Here lawsuit, if after resignation has been placed lawsuit, if you want to withdraw lawsuit, if that withdrawal is not permitted lawsuit, then reason has to be given their lawsuit. That's what it says lawsuit.
okay.
Not that lawsuit.
No, but why you have not accepted the resignation? Why are you keeping this man hanging?
Lawsuit is a submitted lawsuit. The matter was sub judice before this honor court lawsuit, as I've submitted lawsuit.
That has been taken care of by the single judge.
And vigilance clearance was not yet placed before the lawsuit.
What is that vigilance clearance?
Lawsuit, any lawsuit, criminal or departmental proceedings are pending against that person lawsuit.
Why is the vigilance not submitting? Why is the vigilance taking so long? When actually the letter for resignation has been submitted in the month of August 2023?
Lawsuit, that part lawsuit, because vigilance department was not even made a party in the petition lawsuit. So that part lawsuit is not lawsuit. It was not before the learned single bench lawsuit.
Okay, precisely tell us what is wrong with the order passed by the learned single bench. What is wrong?
Wrong is that lawsuit. So for acceptance is concerned lawsuit, that has to be done by the lawsuit accepting.
That is okay, unless they accepted no.
Then second is lawsuit. There is no deemed provision in the rules lawsuit. Honorable Supreme Court says lawsuit, every resignation or retirement shall be governed by the rules lawsuit.
So what is the rules then?
Rules is, as I've read our lawsuit, it has to be accepted by lawsuit. There is no deemed provision in the rules lawsuit.
Under what circumstances it has to be accepted and under what circumstances it has not to be accepted?
Lawsuit, it has to be accepted lawsuit when lawsuit vigilance clearances are their lawsuit.
When vigilance
clearances are their lawsuit, then lawsuit it has to be accepted by the accepting authority lawsuit. And the lawsuit, when the resignation is placed before the authority, on that very day it has to be accepted and deemed accepted. That is not the law lawsuit. And learned single bench has held that that is the law lawsuit, which is not correct lawsuit.
That deemed acceptance.
Deemed acceptance. There is no provision for deemed acceptance lawsuit.
Yeah, page 40, para 8. Page they are here. And they have not.
Then,
But
next,
page 40, para 8. This resignation was given sometime in September.
correct.
Proceedings were filed before this court. There were some in-between proceedings, but this proceeding was filed in January.
January.
Now you had this time, but in paragraph 8, page 40 of your affidavit,
Lawsuit.
you have not been able to bring on record any material concrete saying that these are the allegations or these are the things which factors which prevents the government from accepting that resignation. Here, you only say formalities are not completed. Can you take time for completion of formalities in this manner?
Lawsuit,
I think there is a motive to keep this man hanging.
can we come to page 39 lawsuit? Page 39 lawsuit. This is part of the para 3 lawsuit. The top lawsuit. The department unable to consider the resignation submitted without supported by
No,
vigilance.
not on that. Not on that. You had 90 days.
Ah.
You were the department. And by the time you filed this affidavit, more time was there. What prevented you from bringing on record materials? Say that these are the reasons why we will not consider. These are technicalities. But what are the reasons behind it? Whether there is a contemplation of a departmental proceeding against him, whether he is involved in a criminal case. Because you yourself say in paragraph, page 40, para 8, that you want to leave this man. You want this man to go. Come to para 8. Begs to state, third line, the department do not intend to retain the petitioner, wishes to resign from service. But what prevented you from completing the formalities? Why have you not brought on record? And even in your appeal, not there.
Lawsuit. So far, that is concerned lawsuit. What is the lawsuit? The intents of this paragraph 8 lawsuit. It says lawsuit with formalities. What formalities lawsuit?
No, no.
Those vigilance clearance.
I'm not on
See,
90
Mr. Tapin, we are not concerned with the formalities.
Lawsuit.
We are not concerned whether you will accept the resignation or you will not.
Lawsuit.
We are not concerned about that.
Lawsuit.
Why?
We are only concerned that you had sufficient time to consider the application for resignation. But what is the reason behind the government not accepting the resignation? That is the issue. You had sufficient time.
Lawsuit.
You are only banking on the issue that the government is yet to accept the resignation. We are not on that.
Lawsuit. Here, what I'm submitting is lawsuit. Lawsuit. So far, the lawsuit vigilance clearances are concerned lawsuit. That's being made by the lawsuit vigilance department lawsuit. And accepting authority is this geology and mining, a different authority lawsuit. This authority has to act lawsuit when these clearances are placed before them lawsuit.
Why? Did you ask for? Did the
Because vigilance department
on its own will not come and give you that? You will have to ask.
Mhm.
You will have to ask. The
Lawsuit.
geology department will have to have, we have got a resignation letter. Kindly give us a report whether anything. When did you make that? When did you requisition that report? You were just sitting over the matter and taking a technical view. And maybe that is what led the single judge to pass this on.
lawsuit, yes, I submitted lawsuit when the matter was partly lawsuit.
We give you a short date, Mr. Tapin. We give you a short date.
But
You-
these are the things which you have to cover
So
up.
the notice.
Lawsuit, one submission lawsuit. Lawsuit, the learned single bench law. so far accepting power is concerned, this is the authority lawsuit, the accepting authority. That power cannot be substituted by this.
There is a decision,
No, no, no.
old decision, Manjushri Patak. Under similar circumstances, Guwahati High Court. There is a decision, Manjushri Patak, long back. Maybe even I was not in practice, maybe. There is a decision yesterday, I could not lay my hand on that. There is a decision.
Lawsuit,
Covering this point.
lawsuit, I brought the judgment lawsuit.
Manjushri Patak.
No, not Manjushri Patel lawsuit. The Honorable Supreme Court lawsuit. Every resignation shall be governed by the lawsuit.
No.
And that a part lawsuit.
No, Mr. Tabin, no quarrel on that. Only thing we want to know from you is that you get a resignation letter and you sleep over it. And you act promptly, saying that this is a resignation letter, so the requisite thing collect. We don't find here the second part. You are just sitting and taking a plea.
Lawsuit, basically pleadings are responded accordingly what is pleaded in a read petition lawsuit. That part also lawsuit.
Yes, we will give you a short date.
We'll protect you.
You come and satisfy this court as to why you have not taken any action on the resignation letter submitted by the respondent.
And partly
You also come as to why the observation made by another single judge.
and partly
That deemed resignation is not permissible. You come.
lawsuit, yes, I pointed out the lawsuit.
No, what we find here is that the Honorable Single Judge, Learned Single Judge had proceeded in that line because of your inaction.
Ah,
That's the impression we get. We don't know.
In that case, law, the single judge should have directed the authority to act upon the resignation within a time frame lawsuit.
okay.
And then a part lawsuit, the vigilance clearance, how the vigilance clearance is required lawsuit. That is a page 60 lawsuit.
Page 50
Page 60, 6060 lawsuit.
and come to page 60.
60 lawsuit.
You come to this, there
Page
is
50
another
lawsuit.
notification of you.
Paragraph 4, 3 and 4 lawsuit.
Just a moment.
Page 60 lawsuit.
If you can just come to page 47.
Page.
Right?
Yes.
This is the for the purpose of vigilance clearance, for the purpose of promotion, retirement, deputation, MACP, application for passport, application for ex-India too.
Correct lawsuit.
Where is that?
Correct lawsuit. Then kindly come to page 60 lawsuit.
60.
Page 50. Yes, here lawsuit the vigilance clearance is required. The undersigned is directed to say that the questions have been raised from time to time regarding the requirement of obtaining a vigilance clearance in respect of an official before acceptance of
This will
resignation.
not apply because this is against a person who is under cloud, sick, under suspension.
Lawsuit, kindly come to para 3 lawsuit.
Three.
Next page. This is not for that particular lawsuit.
Okay.
There is for all the categories lawsuit.
Subsequently, it has been concluded.
Para 3 and para 4 on lawsuit. Even the acceptance is required to be approved by the head.
Okay, you show us that last line. Come to the last line. We accept your time. Para 3 last line. When an authority refers a case for vigilance clearance to a court, clearance should ensure expeditious. So when did you refer this matter? Geology department, when did it refer this matter for vigilance clearance?
Lawsuit.
When did you refer? Because in all the pleadings that are there, this is not there.
Lawsuit.
Why?
Lawsuit. That part lawsuit, therefore lawsuit, that part is not their lawsuit. But that part is not there because affidavit was lawsuit filed responding the pleadings made in the writ petition.
Affidavit
So,
also
Mr. Tapin, your submission is that if a person, an employee submits a letter for resignation,
No.
you can perpetually withhold
No, not that lawsuit.
that resignation.
Not that lawsuit. No,
That is your line of submission.
not that lawsuit.
You are not giving reason.
My submission is that in that case, lawsuit, if the authority is not acting upon the lawsuit, what he should have acted lawsuit, then lawsuit, this honorable court should have lawsuit, direct them to act upon that lawsuit.
this is a
But not substitute that very power lawsuit. That's my lawsuit submission.
no, this is a equity court also.
Lawsuit, here,
If you have not done what you have to. do-
Lordship is well aware, Lordship. While sitting in the Lordship,
Yes.
in the forum, the read.
Heard Mr. S. Tapin. The then senior government advocate for the appellant state. The present appeal has been filed.
Twenty-four, 1/2024. Page 1.
Impugning the order dated 24/1/2024, passed by the learned single judge in WPC 597/2023. So, issue notice to the respondent. Returnable in 2 weeks. 2 weeks. In 2 weeks' time. The learned counsel for the appellant shall take steps for service of notice upon the respondents, upon the two respondents, upon the respondents.
Sole respect.
1, 2,
Yes.
4, 4. Upon the
Sole respect, with petition.
it's upon the respondents. So upon the sole respondent by registered post with AD within a period of
3 days.
no, within a period of in the course of the day. Just 2 weeks. In the
Can
course
you
of-
take personal service on, trustee service?
State bar Lordship, I cannot say.
As also by usual process and also by usual process. This, what is this, IA?
I Lordship interim. Till the returnable date, Lordship. Otherwise, it will.
Mr. S. Tapin, the learned senior government advocate for the applicant. The application has been filed for stay/suspension of the judgment and order dated 24/1/2024, passed by the learned single judge in WPC number 597 AP/2023. So we have heard the learned senior government advocate. And considering that the matter needs further examination, we are inclined to stay the judgment and order dated 24/1/2024, passed by the learned single judge in WPC number 597 AP/2023 listed.
But you get, if you require, file an additional letter to the council.
Correct.
Item number 4. May I please, Your Lordship? My lord, in this case, we have filed affidavit reply today, my lord. Today. We'll serve them a copy.
We list it next week,
Yes, sir.
okay?
When do
As
you
per in the
comfortable? If you have any date, you can say you're coming from outside.
my lord, if possible, can it be in the month of April? Then March, my lord, any date, my lord, March,
March first week, second week, whenever it's convenient.
or second week, my lord, second.
Mr. Sanso, you are the counsel for the petitioner.
I am for petitioner.
The learned counsel for the petitioner submits that he has filed the rejoinder affidavit on behalf of the petitioner. The learned counsel for the petitioner shall serve the copy of the rejoinder to the learned counsel for the respondents. Stop. On the prayer of the learned counsel for the petitioner listed on any specific date?
My lord, on 15th, my lord.
Listed on 15/3/20, okay? 15/3/2023.
Obligation.
The work is progressing. Give a status report on that also.
May it, Major Lordship. This is a matter regarding a dispute for construction of a road. It's a greenfield project. Construction of a road in that far-flung area of Upper Subansiri district from a place called Tato to Taliha to Tato. Now, the dispute herein is related to an alignment issue. Now, as it is that today the matter is there for service report. And the
Respondent number 9.
respondent number 9, but I would like to submit very frankly, in fact, 3 times we have taken steps upon them. My entire allegation is against respondent number 9 because they were the consultant agencies who had given this alignment to which we are totally dead opposed to because the alignment is not feasible. There are various grounds to say why this alignment that they have particularly projected here is not correct. Now, leaving that aspect aside, I'm not asking your lordships to enter into which alignment would be correct, the one that the PIL petitioners are saying, or the one that has been given by this particular agency. The issue is they have to follow a methodology, a procedure. Now, the BRO, who are the agency who will be implementing this entire road activities, have filed their affidavit. They have stated therein that yes, the Indian Road Congress, which is the apex body which gives the guidelines, have been followed in toto. That's their affidavit stand. Now, the Indian Road Congress, that particular guideline specifies that there has to be physical verification of the road. Nevertheless, it's a greenfield area. There's no road there. People are expecting a new road to come there. So when an agency would go there, they will definitely have to go for a field verification. That is essential. The Indian Road Congress very categorically says that. My entire allegation is that physical verification never took place because this agency is an agency from Delhi.
Physical verification never took place and
Never took
they have
place.
diverted the project.
And the project has therefore been diverted in a way that wherein all the requirements of a proper road will suffer. It's a hilly terrain, which is totally difficult for a road construction. In fact, the project was taken in 2010. In 2022, after 12 years, the MORT has foreclosed that project because the road could not be made in that area. The petitioner, the PIL petitioner,
The previous project.
the previous project, for 12 years, they tried. It was foreclosed. Now, thereafter, a new agency came. They were asked for this particular alignment. Now, it's basically to reach 2 particular points. From Taliha, there's a place called Taliha. These are all frontier highways in the upper reaches of the borders. From Taliha to Tato. Now, we have given a map here. The map will also indicate that the road that we are proposing would be through a particular terrain, which is very much feasible, short in distance. And in fact, there has been a road cutting by the PMGCY projects that already that road cutting is also there. So the most feasible way would have been through that route.
Who are you, Mr. Amusman?
I am an organization, a registered organization of that particular area. It's called the Sealing Valley People's Welfare Forum. We are basically from that area. This forum is from that area, as well as the petitioner number 2, who is the APSU, that is the Arunachal Pradesh Students Union. That is also a very prominent organization. There is no, as your lordship is thinking, whether it is a public interest or a publicity interest. It is not a publicity interest forum. There is nothing here that would benefit us. All that we are saying that yes, this is a greenfield project. The road should come through an area where there are public, where there are people's life will be connected. Road is a lifeline. And the other side is a treacherous terrain. There's nothing there. In fact, it is an area where there is no sunlight. All these highway roads, there has to be sunlight there. There's no sunlight in that area also. But again, I'm saying, lordship, I'm not asking your lordships to enter into the which is the better road. My entire case is the procedure has to be followed. The procedure mandates that a physical verification has to take place. The deputy commissioner of that area, Daporiju, categorically in their affidavit have stated that yes, no physical verification took place. In fact, the engineer who is engaged for that particular work in an RTI reply have categorically stated that no physical verification have taken place. So in that view of the matter, and in fact, the affidavit filed by BRO, in their affidavit, in their paragraph, they have stated physical verification took place. It is enclosed as annexes such and such. If a lawsuit will see their affidavit and their enclosures, the annexes, that physical verification report is conspicuously missing. A lame statement is there that physical verification took place, and it is enclosed here in the affidavit. I have checked the affidavit again and again. I could not come across that document. The Deputy Commissioner Daporiju have categorically stated verification is not there. The engineer concerned for that particular area in an RTI reply has said physical verification never took place. So if physical verification never took place, how could you have given an alignment? How could you have said this? And this particular consultant agency is never before this honorable court. 3 times we have given them
Who is
notices.
respondent number 9?
That is the agency who was entrusted the responsibility of giving this particular alignment.
So he is one of the main party.
He is one of the main parties. 3 times we have given notices have reached them. In fact, I think they have sent the email also. Respondent number 8, Lordship, not 9. Respondent number 8.
We direct the respondent number 7 to serve the
6 and 7.
notice. 6
Who
and
had
7.
engaged respondent number 9? Who had engaged?
Respondent number 9 by Ministry of Roads. Mort.
But the thing is done by the Border Roads Organization.
Yes.
So they will know where this respondent number 9 is.
In fact, notices have reached them. They have also filed an email. They have sent an email to the registry. And I haven't gone through that email, but an email has come to the registry, which was indicated by the counsel for BRO on the last occasion. I think it is there on the records also. That means notices have reached them. They are in knowledge. All that they care to do is to send an email to the registry of this High Court. Mr. Marto Kato, who is appearing for the Border Roads Organization, have categorically stated that they have sent an email.
To what extent?
I'm not privy of that email, Lordship. But my statement is 3 times notices were taken. They know about it, but they are avoiding the process of this court because they know that they are wrong. They are wrong somewhere, which I am now pointing out in this PIL. All that I'm asking is there should be a fair survey, a fair road should be therefore constructed. And our petitioner's personal interest is that it should be constructed by the route that we are suggesting because that is the most feasible route. But then I leave it to the agencies for that, the experts for that.
Your long and short of the story is
Yes.
that this is going through a forest area.
It is going through a treacherous terrain
Treacherous
where
terrain.
already for 12
This
years they
should
tried,
be-
they failed.
This should be brought and aligned with your villages.
Yes. That is the
That is the thing. And
high
then
hope
the
we
conse-
have.
Then the consequences, whatever are there, will follow.
Yes.
Right?
But then I'm not asking your lordships to pass an order on that aspect. My case is that what they are trying to do today is illegal. That has to be stopped. And therefore, a transparent process of survey has to take place. And in the transparent process of survey, whichever road they find to be the genuine road, they will do that. The genuine alignment, they will do that. But this is a farce. What is happening today is a farce. Without physical verification,
Now,
they're
today,
proceeding.
the road that is being aligned is not through any person holding that plots. Nobody is holding those lands. It's in the forest area.
There are forest land and there are areas where there are people's land are also there.
Then-
But
then-
yes, but then what I'm saying is
Hmm.
that route has not been ultimately selected by way of a physical verification, which is mandated by the rules regulating the whole field.
That is for the executing agency and the government to
Yes,
look into.
yes.
How can you demand?
No, because this is an illegal process going on. Ultimately, public money is at stake.
Show me the law which says that these are the processes that you have to follow.
Yes, the Indian Road Congress, which in the BRO affidavit, they have categorically stated that they have complied in toto with this.
Then
But they have not.
Show me,
Yes, I'll show that.
show me.
Yes. First I will show.
You show me, okay, road congress, we have seen the affidavit. They
Yes.
said the provisions of the road congress has been in toto followed.
Yes, that is
Now
the
show
BRO's
me
affidavit.
how it has not been followed.
Yes. If your lordship will come to that road congress compilation that I have given.
You show me from your statements,
Yes.
how the statement of the BRO is wrong.
If your lordship will come to that, this is affidavit. Number one. The Deputy Commissioner Daporiju.
Hmm.
His
Page.
affidavit.
Page,
Page 7, paragraph number 10.
Respondent number 2.
Respondent number 2, yes, your lordship. The Deputy Commissioner had asked the BRO for the specific documents, which included the physical field verification and the joint physical verification. I suppose got that. It's an affidavit filed on 13 to 2024.
Which para?
Paragraph number 10, page 7.
no, this is you who have sought for,
Yes,
then,
but that has been forwarded by the Deputy Commissioner. I can produce it later also. That letter is there in the BRO's affidavit. I'll produce it later. I'll just show that later. If you also will see the documents that has been sought for. Number 1 was the physical field verification. Number 2 was the joint physical survey report. Now what is stated? But the respondent number 6, the commandant such and such, did not furnish the above mentioned documents till date. Moreover, it is clear from the record furnished by the AE Civil BRO Taliha that no field survey, joint field survey was done along with the DPR consultant MS Ignicio Infrastructure, which is the respondent number who is not responding to your lordship's summons. From 0 to 30, which may be seen from page 20, annexure E2, which your lordship will find at page 20, E2. This is by that concerned, competent executive assistant engineer civil. Page 20, last page of the affidavit. The last paragraph lordship will see. I have remained as officer in charge of Taliha, of Department Taliha from August 19 to 10 April 2023. And during this incumbency period, no field survey or a joint field survey was done along with the DPR consultant 0 to 30. This is the concerned area, except existing BRO road of 6 km, CC Sika Bridge. So there has been evidence to indicate or to give a clear direction that yes, there was no survey been done. And in the BRO's affidavit, though the BRO's affidavit says that survey was done, and they also say that I have annexed these documents in this affidavit, well, lordship will see that physical verification is conspicuously missing. That is not there. If your lordship will come to yes, paragraph. Lordship is taking up the affidavit by the BRO. Paragraph number 7.
Paragraph?
Paragraph number 7, page 4. Page 4, paragraph number 7. It says, the answering deponent states that the DPR consultant has carried out field ground survey and deliberated out of the 5 alternate alignments. Now, they say that it has been annexed as annexure 1. Again, at page 6, if your lordship will see, page 6, your lordship finds that they are referring to the DC Daporijo's letter of 12 June 2023. I'll just place that. And they have said has already been forwarded to the deputy forwarded to the DC Daporijo as Appendix C. Number 1, they are saying the physical field verification annexure 2. But if your lordship will see these annexures 2 here in this affidavit, it is not there. I'll just place that letter at page 18. The DC Daporisu's letter, which the DC has referred to in that affidavit of DC. That will also will find at page 18 of this affidavit.
Page
Page 18. The Deputy Commissioner. Page 18. Lordship will find that those documents were asked for, the physical verification, field verification, everything. But if your Lordship will thereafter see the documents that have been annexed here, that report is not there.
page 18.
Page 18 is the Deputy Commissioner's letter to the BRO asking for the physical field verification reports. That, and it will be a big report because everything, the photographs and everything has to be there. They have asked for that. Now, in reply to that, the BRO at page 20 writes to the Deputy Commissioner. Page 20. In reply to his 12 June letter, the BRO writes to the Deputy Commissioner on 8th of August, and therein they say, also, point number 3, also following informations appended as desired in the above referred letter. Number A, copy of the physical field verification conducted as Appendix A. Now, if your Lordship will just turn and see that document, the next page. This is not the field verification report. Nothing is there.
Next page is Appendix D.
Yes, Appendix D. So this is what they have annexed here. This is BRO's affidavit that I'm reading. They start with Appendix D. It is not there. In the affidavit, they say that this has been annexed to the affidavit. It is not there. So everything, therefore, points the needle of suspicion to these authorities, not basically the authorities, to that agency, that there has been no compliance of the required mandated provisions of the law. And therefore, I say that this is a farce. Public money is still at stake.
Now, what is the state with regard to that proceedings under the land?
We are being protected. There is an interim order, yes, whereby the acquisitions have been stopped. In fact, there was no notices also out. They were just contemplating. This honorable court has stopped it. A third party that should be otherwise created. So this is the position.
Will it be proper to issue notice to the respondent number 9 through 6 and 7?
9, we have nothing. It's 8. Because this is a road of respondent number 8, Lordship. I'm sorry, I was also saying as 9, but it is respondent number. No, respondent number 8, Ignicio.
Unserved notice was returned back on 13/2.
In respect of respondent number 9.
Against 9, we do not have.
Unserved in respect of 8 is returned back.
8. We are concerned with 8 because this particular stretch of road, the consultant agency was Ignicio.
But the notice has been returned back unserved.
Unserved again.
Unserved. Unserved notice in respect
But
of.
earlier also 2 times we have sent. This honorable court wanted us to send notices, so I have complied with that 3 times now.
We'll ask the Border Roads Organization.
But there was some email. There was some email sent by them. It is not on record.
So what is this office note? Service report in respect of respondent number 9. 9 awaited.
8.
8 returned.
8 returned as unserved.
So notice has to be served on both these respondents, 8 and 9.
So if it can be done by the BRO organizations directly, because they were their people, their agencies. Because otherwise we have failed now. 3 times we have done it. And these are registered addresses to which we are sending. These are the registered address. Delhi organizations registered address. Now, if they are not there, if they have packed their bags and left, I do not know. But these are people who have taken government money in the name of a road alignment project, and this is what they have done. So there is an angle of corruption and misappropriation of public money also involved in these matters, apart from what we are claiming and what we are praying for.
6 and 7.
6 and 7 has filed affidavits. They have
No,
filed
No,
affidavits.
we want to issue notice
Mr.
through
Who
6
is
and
appearing
7.
Oh,
for
yes,
6 and
yes,
7?
Lordship.
M. Kato.
Mr. Marto Kato, yes, he is appearing.
Respondent number 4 to 7, madam.
So
4 to
Given
7.
in opinion. As per instruction given by the DAGI, he served the notice to the respondent number 9 and 10, and 8 and 9.
8 and
When?
This is the issue.
last time also some orders were passed.
No, this is by you. No, we don't want you to do it. This is by them. This, we don't want, we want the ministry to do it. You send it to the ministry, ministry will serve it on them and file an affidavit. That will do.
You take fresh steps for service of notice. We will also direct the office to take steps upon respondent number 8 and 9 through respondent number 6 and 7.
Through respondent number
8 and
4.
6.
4.
Ministry of Road and.
Yes, yes,
Secretary.
Lordship.
The Secretary.
4.
And they have also not filed their affidavit. Mort has also not filed their affidavit. Because the BRO affidavit also says that Mort has otherwise also approved, but then that document is also not here.
Third, Mr. A. Sharma,
Yes, Your Lordship.
learned counsel for the petitioner.
And so,
Who are the parties? Mr.
on behalf of.
So and so, learned counsel appearing on behalf of Mr. M. Kato, the learned BSGI for the respondent number
4 to 7.
4 to 7 and
I'll be for 2. Respondent 2.
MS so and so. MS so and so, learned government advocate for the respondent number 2 and
I'll also buy for respondent number 1 and 2.
Mr. So and so, the learned standing counsel. Standing counsel,
Yes, Lordship.
the learned standing counsel, land management for the respondent number 1 and 2.
I'm appearing for respondent number 1 and 3.
1 and 3 for the last for the respondent number 1 and 3.
And I think for respondent number 10 and 11, Mr. Marto Kato can, because he has filed an affidavit for them also.
10 and 11 will be with you.
Yes,
10
because the affidavit indicates that they have filed
10,
for
11,
them also.
10, 11 also with the BSJ.
So only 8 and 9 is the problem now.
Mr. Teshama, the learned counsel for the petitioner shall once again take fresh steps for service of notice upon respondent number 8 and 9 by registered post with AD as well as by usual process within a period of
2 days, Lordship.
2 days.
2 days.
Within a period of 2 days from today, and shall file affidavit to that effect. Stop.
Parallelly, they should also.
Registry, will direct the registry.
No, I think parallelly they should be also directed.
Sir, you can direct, sir, the ministry of Road Transport.
Let them also, because
To intimate
The
respondent number 8 and 9.
respondent number 4 shall take steps for service of notice upon respondent number 8 and 9.
Respondent number 8 and 9, that this matter is coming up again. So I'm saying.
Shall intimate,
and file an affidavit to that effect.
shall intimate the respondent number 8 and 9
About the next day, fix the bill.
that the matter shall be listed again on
22nd of March if it is otherwise not important.
22/3/2023. Mr. M. Kato, the learned BSJ, to take steps accordingly. Okay? And file affidavit to that effect. Listed on
Two extra copies of the petition.
I'll do that.
Is it necessary?
Because he sent it to ministry.
I'll do that. I'll do that, Lordship. I will serve.
The learned counsel for the petitioner shall serve two extra copies to the learned BSGI for service
On respondent number 8 and 9.
To respondent number 4 on respondent number 8.
to service to the respondent number 8 and 9 through the respondent number 4.
Yes.
Listed on
22nd of 22nd of March, Lordship.
Did we say 22nd? Listed on 22/3/2024. Okay.
There's an interim order that may be continued.
The interim order passed earlier shall continue till the next returnable.
Deeply obliged, Lordship.
Item number 7.
Please, Your Lordship.
Yes.
I'm appearing as amicus in this case. It's an appeal against conviction. The impugn order dated, impugn judgment and order dated 24/7/2020. Is at page 51 of the paper book,
Page
51 of the paper book. Conviction is under 302. And she has been sentenced to imprisonment for life, of which period of 2 years shall be under RI and a fine of ₹3,000. In default, to further go detention for 3 months in custody. Now, Lordship, this case emanated out of FIR complaint that is at page 1 of the paper book. The convict has been, she's been convicted of killing her husband, and the complainant is her son.
Madam, we listed on 4th.
Lordship,
My lord would not be here after this week, so if
We
we pass
listed on
this one, it might be.
Maybe it'll be a long hearing.
Hearing.
Again, judgment.
obliged.
4, okay.
Okay.
Listed again on 4/3/2024.
Item number 8.
My lord, I made this mention for withdrawal of the writ appeal member.
You're the counsel for the petitioner
Yes, for the appellant.
for the appealant.
Yes.
So we closed as withdrawn.
Yes.
Mr. So-and-so, the learned counsel for the appellant submits that he has instructions to withdraw the writ appeal. The writ appeal accordingly stands closed as withdrawn. Okay.
Well, yes.
Is out of station, my lord. Can
T.
it,
Gadi,
yes, T. Gadi, my lord. Counsel for the petitioner. Can it be listed on 5th of March, my lord?
Mr. So-and-so, learned counsel, makes a mention on behalf of Mr. T. Gadi, the learned counsel for the petitioner, and 6 adjournment of the case on 5/3/2024. Prayer is allowed, listed accordingly.
My lord, obliged.
My lord, I beg to mention item number 8, my lord. With consent from the other side, my lord. I pray for some time to file rejoinder, my lord.
You are the counsel for the petitioner,
I am for the petitioner, my lord.
Mr. S.K. Dury.
Yes, my lord.
Mr. S.K. Dury, the learned counsel for the petitioner, 6 for 2 weeks' time to file rejoinder affidavit. Prayer is allowed, listed accordingly.
Well, there is an interim order that may be funded.
The interim order passed earlier shall continue till the next returnable date.
Apply.
May I please, my lord?
Yes, please.
My lord, I, I beg to mention item number 2 and 3, my lord.
2 and
3, motion item, my lord.
Ah.
My lord, consent from the other parties, my lord. Can it be listed tomorrow, my lord? Due to some personal difficulties, M. Kato is unable to appear today, my lord.
Why? 2 and 3?
M. Kato is unable to appear today, my lord. Can it be listed tomorrow, my lord?
Pass over for the day.
Deeply obliged.
No, no, no.
Yes, please.
My lord, I beg to mention item number 7.
Item
Number 7.
7.
My senior leading counsel is absent.
Who
Is
is
out of
your
station.
counsel?
C. Modi.
C. Modi.
Matter may be listed up to 1 week.
Counsel for the
Petitioner. Petitioner.
C. Modi.
C. Modi.
Mr. So-and-so. Makes a mention on behalf of Mr. C. Modi, the learned counsel for the petitioner, and seeks adjournment of the case after a week on the ground that the learned counsel for the petitioner is out of station. Prayer is allowed, listed after a week.
Lordship, I beg to mention item number 24, Lordship. Lordship, we need some more time here, Lordship. I was asked to take some instructions, Lordship.
Item 24.
Lordship, yes,
Hearing item, your lordship.
Lordship,
There is
hearing
no-
item.
Instruction was sought for from the government.
Lordship, that's why I'm asking for some more time.
MS Senso, the learned government advocate,
Yes, Lordship,
6 for how much time?
2 weeks, Lordship.
6 for 2 weeks' time. 6 for further 2 weeks' time to receive instructions. Prayer is allowed, listed accordingly. Okay.
Much obliged, Lordship.
My lordship. I beg to mention item number 14 on mentioning on behalf of DSJ M. Kato.
Item,
14. Can it be fixed on 6 March?
you are mentioning on behalf of
DSJ. Matu Kato.
M. Kato.
Yes, yes, my lord.
Okay. Mr. Senso, learned counsel, makes a mention on behalf of Mr. M. Kato, the learned DSJ, and seeks adjournment of the case when?
6 March.
On 6/3/2024. Prayer is allowed, listed accordingly. Okay.
Much obliged.
Mayor, my lordship.
Yes,
I
please.
beg to mention item number 13, my lordship, on behalf of Mr. S. Tapi.
1/3.
Yes, my lordship. We have to take steps on private respondent, my lordship, so we need some more time.
Private respondent.
Yes. ma'am. Maybe listed after 2 weeks.
MS Senso, the learned government advocate,
Yes. ma'am.
submits that some time may be granted to take steps for service of notice,
Yes, my lordship.
to take steps for service of notice upon
Respondent number 1 and 2, private respondent.
the respondent number 1 and 2. Prayer is allowed, listed after 2 weeks.
And one more, like, item number 18, my lordship. In this service is awaited, my lordship, so some more time, maybe. After 2 weeks. Item number 18.
Let us see the report. Let it come as per the list. Let us see. Okay.
Lordship, beg to mention item number 11 on behalf of my senior Tabatagum, standing counsel for the health.
11
Yes,
on behalf of
Ms. Tabatagum.
Tabatagum.
Yes.
Yes.
We have informed the parties. We have their consent.
Pardon?
With the consent from the other parties, we have also informed the other parties for the same.
No, this is for, my lord, not for adjournment.
Uh,
Here only they have to file the affidavit. On behalf of respondent number 1, 2, and 7, they have filed. And this is the standing counsel for health. That is representing respondent number 3 and 3 to 5. They have to file an affidavit.
Okay, let it come as per the
Let it
list.
come.
Let us see. Let us see. Yes.
May I, Lordship, I beg to mention item number 25 on behalf of A Tatak, private respondent number
On
4.
behalf of
A Tatak, Adam Tatak,
A,
A Tatak. Adam Tatak,
this is learned counsel for the respondent.
4,
For the respondent number 4.
4, private respondent. The matter may be adjourned, Your Honor, and may be listed after 4 weeks.
Why 4 weeks?
He is out of station due to health issue.
Mr. Senso makes a mention on behalf of Mr. A Tadak, the learned counsel for the respondent number 4, and seeks adjournment of the case after 4 weeks on the ground that the learned counsel for the respondent number 4 is undergoing treatment outside the state. Okay,
Obliged.
prayer is allowed, listed accordingly.
Obliged.
Item number 1.
Yes,
Lordship, in this case, this writ petition has been filed challenging that is execution order this passed by this additional deputy commissioner. In this case, Lordship, as per the AFR 1945, the competent jurisdiction to settle the case is a village authority. Lordship, village authority. Already village authority, the proceeding in the Kavang, village proceeding under village authority was going on. And in the meantime, as per the decision of the village authority has passed an order directing the party to settle the matter mutually.
where is the order?
Yes. Kindly see, Bangok, this page number 18. This is the translated copy in English. Kindly see, may I read the contents?
Just wait.
This. On the day,
This page 18.
18.
Page 18. This is the order
On the-
passed by.
On this day, 18 June
This is
2000,
the order passed by.
by the village authority.
This is dated 11/6/2022.
Yes, 11/6/20.
Just wait, dated
Yes.
11/6/2022.
Yes.
This is the order passed by Mebo Village Kebang.
Yes, Mabo village. At the village level, as per the village, as per the this Arunachal Pradesh Civil Code Act, this is the customary court.
Mebo
But
Village Kebang.
village Kavang.
This is a
Customary
statutory
code. Yes, customary code. Village level. Kavang.
Recognized code.
Yes, customary code.
Mebo Village. Kebang.
As per this decision on 11th of June 2022, Kavang was convened at Mabo village. Kavang has been convened by the Riju Megu by alleging the WRCP of Witlek Arik, on which he has been defendant for his entire life, has been
This Riju Megu is the
a
petitioner.
respondent. I am the Tikathaim. Respondent. As per the what is the decision of this operative person is kindly see the last paragraph. The discussion should be completed within 11 days. 11th June 2022 to 26 June 2022. And the findings should be informed to the Kavang during the pendency of this Kavang. Both the family will not cultivate the disputed land.
What is this discussion? Discussion for amicable settlement?
Yes, this party has, this court has, this customary court has authorized the party to settle the matter at village, this at personal level, a personal level. Within time period has been prescribed within 11 June to 26 June. It is about a week, about a week. And in the meantime, the status quo order has passed not to cultivate the village. And this, as per this decision, the decision of the party was to be submitted before the Kabang authority for final decision. Kabang authority, the decision of this disputing party was to be submitted before the Kabang authority. But is this private respondent, who is my private respondent here, instead of this settling as per the court direction, village authority, he has appealed the matter, file an appeal. Whereas file an appeal before the Bango Kabang, which is the affiliate authority of the village authority. In the Bango Kabang, what has happened?
Who is the appellate authority?
As per the this Civil Court Act, this recent amendment, it is the inter-village, either it is Apex Village Council or Inter-Village Council.
Inter-village council.
Yes, inter-village. This is inter-village.
And what is that called?
That is inter-village court is lordship. That is the affiliate court of the customary court.
No. What is that called? Suppose Kebang is in the local dialect.
Local.
And
Local
what is that appellate court called?
Affiliate court is Bango Kabang is
Bango
Bango Kabang is inter-village court.
And that is the appellate court.
Affiliate court, as per this Regulation Act, as per the ordinance for the Civil Court Act. And this case, what has happened? The proceeding of Kabang was on the way because this village council, village authority, the customary court was yet to dispose the matter, in which the party has been given a chance to settle the matter as per the disputed side by re-verifying the disputed side and as far as possible settle the matter at their level and report the matter after settlement and all, report the matter after 26 June to 11 June to 26 June. And during the pendency of this proceeding, the land was not to be cultivated. That was the decision as per this 11 June 2022. In violation, then it starts violation. In violation of this Kabang decision 11 June 2022, this private respondent has filed an appeal before the inter-village authority, that is village Bango Kabang, inter-village authority, that is Bango Kabang, which is the affiliate forum. Whereas matter was yet to be disposed of from the village authority. That is the issue, crux of the issue here. Then, on the basis of appeal, order has been passed without disposing the main Kabang, whereas Kabang was yet to be disposed of. Kindly see page number 28 is there. Now Bango Kabang. Page number 28 of this petition.
Page number
28,
28.
28. This is the Bango Kabang. This is the appellate forum. My respondent has brought the matter before the appellate forum, saying that
Just wait.
the decision of the
Let us just wait. Let us. 26,
28.
11/26.
Yes. 5th November 2022.
Under 15.
Decision dated is date of the decision. 28 of the
But, as per the Kabang's decision,
yes. Kabang
the discussion should have been completed between 11 to 26 June.
Yes,
That could not be done.
yes, that was not done.
So this respondent the private respondent filed an appeal before the Bango Kibang.
Bango Kebang.
Bango Kibang.
In place of,
On 15 November 2022.
yes,
What's wrong?
Lordship, the issue is that when the matter is yet to be disposed of by the village authority, when it is disposed of, then in that case, if the parties agree, then he may move to the higher court, appellate court. But when the matter is yet to be disposed of, when the matter is pending, then the private respondent has,
And if the Kibang does not dispose, what is the recourse?
Kebang,
If the Kibang does
has,
not dispose.
Kebang has given the timeline to dispose the matter. As per the,
That's why it could not be. You see the Kebang's order. Kebang's order is to discuss and complete a discussion between 11 June to 26 June 2022.
may I again repeat, take your lordship to page number 18. What is the decision of that 11 June 2022? Kebang has said there are four directions, four number of directions. Majority of speakers in today's Kebang.
No, that is okay. I am on number 4.
Yes, number 4. Kebang is, as per the number 4, the discussion should be completed within 11 June to 22, June 26 June 2022. Within that time frame, the discussion was to be done. But instead of doing that, as per the court direction, he has filed an appeal before the appellate forum. This is the issue. When the matter is not disposed of, the party has no jurisdiction to file appeal. This is the issue here. As per law, this when the case is pending, without disposing that case, the party cannot go in the higher forum, because legality and validity of that issue was yet to be settled. That is why I am saying, Lordship, this decision of the appellate court is in excess of the jurisdiction.
What was the decision of the appellate court?
Appellate court said that, Lordship, kindly see this. Appellate has said that ruled the case in favor of this page number. This appellate has said in favor of this private respondent. It has said November 2022, annexure page 20. What is said? This is a very short judgment. Today, as per this operative person, today, all people present in the Kebang has decided in favor of Riju Megu. This is the respondent here, because father of the Riju Megu led Topok Megu and purchased the disputed land in 1967 from Patoni, and led Bundor Patoni has purchased the same from led Tobuk Tayeng Siri. Riju Megu has produced the documents of sale and purchase before the Kebang today. The other reasons for deciding the matter in favor of the Riju Megu by his peers were, during the last 46 years, Kibang family have never objected, and out of nowhere the Kibang family has arbitrarily entered into the land in this year, 2022. The disputed WRC field of the Riju Megu is within the area earmarked as residential land by the elder brother Mebo. However, no objection was raised earlier by the Mebo Kebang. That is why.
Then thereafter?
That's only, Lordship.
Thereafter, what happens?
That thereafter, on the basis of this decision, The petitioner, the respondent has, as per this relevant provision of law, file an execution petition, that too without informing me, without any notice. Degree has been executed without hearing the other party. Page number 32, Annexure C. Executed order. Execution of degree. Yeah, that was degree was executed on 13th of July 2023. It is purported direction is in bus for compliance of the party.
This order is passed by additional.
Deputy Commissioner Mabo. As per this amendment made in this FR 1945, Arunachal Pradesh Civil Code Act, the Deputy Commissioner or ADC is competent to execute the Kebang order, but that has to comply the due process of law. Party has to inform the other party before execution. Is there any objection, legality and validity, and many other issues? Without hearing the other party, just like a note, like a public notice, the execution order has been proclaimed, saying that this is for compliance of the party. This is the issue here. That is why I am praying before this honorable court that that decision of the village authority, that the village Kebang decision is yet to be passed, because proceeding was going on. In the meantime, in exceeding the power conferred under the Regulation Act, under Civil Court Act, the appellate court, inter-village authority has passed the impugned order, saying that decision of the village authority was wrong, whereas village authority was yet to be passed the final decision. This is the case. When the other party is not heard of, and without hearing the other party, the execution order passed that is a violation of the principle of natural justice too, apart from violation of the civil proceeding under Order 21, as well as this, as per this Arunachal Pradesh Civil Court Act. Execution power has been conferred upon the ADC as well as the Deputy Commissioner, but neither the Deputy Commissioner nor the additional Deputy Commissioner has power.
Lordship, here in the beginning, the Kebang, which has been held on 11 June 2022, Lordship. Of course, Lordship, because they could not decide, they have gone to the Kebang. And then Kebang could not give any decision, Lordship. Lordship can see here. Only here the Kebang has put in status quo, Lordship.
Kebang has?
Put in status quo, Lordship. During pendency of this Kebang, both families will not cultivate the Lordship, disputed land. Lordship, whereas, Lordship, this May, June, July, Lordship, this time is cultivation time, Lordship. Most probably, with the dissatisfaction, the other party must have gone for this one, higher Kebang, Lordship, which that is
Bango.
Bango Kebang, yeah, yes. And Bango Kebang have decided in favor of the private respondent here, Lordship. So, Lordship, there is no wrong in this passing of this Bango Kebang, Lordship. Since there is a bigger forum, Lordship, dissatisfied one will always go to that one, Lordship, that forum. And Lordship,
What is the next higher appellate authority after Bango?
no, none, Lordship.
There is no appellate authority after Bango.
No, Lordship.
Sorry, that is after Bango.
In the Kebang system, there is
In the
none.
Kebang system.
Yes,
No,
Kebang-
none.
I am not well conversant with all this.
Final.
Yes,
Final.
none, Lordship.
So against the order passed by Bango Kebang,
Yes,
if one is aggrieved,
yes.
where does he seeks his remedy?
Lordship, of course, to the court of law, Lordship.
The court of law.
Yes, Lordship. And he did not prepare that also. And then when the private respondent had went for execution of the decree, now he's
Yes,
after
learned
passing
counsel
of the
for the
decree.
petitioner. We are finding that you have, irrespective of whether the order passed by Bangko Kibang is good in law or not, you have not appealed against that.
Yes. You have not
You are
challenged,
coming
Lordship.
only against the execution order passed by the ADC.
Appropriate,
There's something wrong with your petition also.
appropriate direction may be passed for this file appellate, approach the appellate.
How can we pass the direction when that is not your prayer?
Lordship, this is matter has been prepared by my friend. That is why I am unable to this.
No,
Matter may
cannot
be.
That we understand, but
Matter may March 4. He will appear. My friend will appear. In this case, for
We
final
are-
disposal of the case.
we are not staying any order.
Yes, maybe. I can refix under,
But without
March 4.
approaching the appellate authority,
yes.
coming straight against the execution order, I think you may have a very difficult time
Yes.
ahead.
Maybe refix on 4th March.
On the prayer of
Right.
Mr. So-and-so, the learned counsel for the petitioner listed again on 4/3/2024.
We will take appropriate steps.
Take steps and come.
Yes, have lives.
Item number 4. Item 4.
My lordship.
Yes, please.
Lordship, here in the petitioners, they were appointed in the AUPO, GE, junior engineers, in the year 2004,
AU,
AUPO.
that is a department.
Yes.
AUPO
This
is a
Yes,
department.
analogous to the junior engineers, post of junior engineer.
Is it a post or a department?
Yes, this is the post, Department of Urban Development,
What is AUPO?
Assistant Urban Planning Officer. And now this post has been designated as junior engineer.
Redesignated as?
Junior engineers. And petitioner 1, petition, and 2, 4, 5, 6, and 7 were appointed in the year 2004
As?
as junior engineer, AUPO. And petitioner number 8 was appointed in the year 2006 as junior engineer. And petitioner number 9 and 10 were appointed in the year 2007. And petitioner number 3 and 11 were appointed in the year 2009. Now, after that, all the petitioners were again promoted to the post of assistant engineer in the year 2017 on officiating basis. After that, there has been no any departmental promotion committee conducted by the department. Their appointment, promotion were purely on the officiating basis. Now, this post has to be regularized by the responding authority in the post of assistant engineer. They were promoted in the year 2017 by order dated number DUD established /2023, page number 35, Lordship, Annexure 1, page number 35.
Page
Number 35. And page number 33, 33 and 35. This is the promotion order, officiating promotion order.
page 33 and 35.
32 and 35.
32 and 35.
Yes. 33 is the type copy.
That means 33 and
33 and 35. They were promoted to the assistant engineer on phase two phases.
this is on officiating.
Yes, officiating. Now this has to be regularized by conducting DPC. Through DPC only. All the petitioners, they have attained the length of required length to be promoted.
What is the eligibility criteria for promotion?
RR 2006.
Huh.
Minimum 5 years of service for those who have possessed the bachelor engineer degree, and minimum 8 years for those who have diploma degree.
So all the petitioners, they have the requisite qualification
Yes.
to be promoted. They have the requisite qualification to be promoted.
Yes. Their promotion, officiating promotion was carried out on the basis of seniority. And they have possessed all the criteria. They have attained the length of 8 years and 5 years, respectively.
What is your prayer? Let us see.
Very limited prayer, Lordship, in fact, for directing the respondent authority to conduct DPC.
What is your representation?
Representation on phase number.
No, what is that? What is that representation?
Lordship.
What is the representation for?
Yes, Lordship, representation was to regularize the officiating promotion by conducting DPC. There are 3 sets of representation has been filed before the authority, but that is just yet to be.
Mr. So-and-so. Learned counsel for the petitioner. The present petitioners who are serving as assistant engineer in the which department?
Urban development and housing.
In the urban development and housing. Were promoted to the post of assistant engineer on officiating basis in between the year 2012, 2017. Stop. It is the case of the petitioners that they are all eligible to be considered for promotion in accordance with the recruitment rules 2006. which governs recruitment and conditions of service in the department. Stop. It is the case of the petitioner that since the year 2015, no departmental promotion committee has been constituted to regularize the officiating promotion of the petitioner as assistant engineer. The petitioners have submitted the representation dated 28/5/2022, 29/9/2022, and 2/11/2022. To constitute the DPC for regularizing the officiating promotion of the petitioner. However, the representation submitted by the petitioner has not evoked any response. Being aggrieved, the petitioner is before this court by filing the present writ petition. Issue notice to the respondents returnable after 4 weeks.
I'm for 2 and 3, madam.
So I'm for 1.
MS Senso, the learned government advocate, accepts notice on behalf of respondent number 1 and
I'm
Mr.
Pitapum
T.
for respondent number 2 and 3.
Standing counsel,
Yes, madam.
learned standing counsel for
Urban development
the
and
urban development accepts notice on behalf of respondent number 2 and 3. No formal notice, therefore need be issued to the said respondents. The learned counsel for the petitioner shall however take steps to furnish the requisite copies of the writ petition to the learned counsel for the respondents within
4 days.
a period of 4 days from today.
Lordship, short date may be given, Lordship, since this is.
Insofar as respondent number 456, respondent number, 42.
Three respondents
Oh.
only.
Oh, only 3.
Yes.
Yes.
It's not respondent.
Shall take steps, just wait, ma'am, to furnish the copies within a period of 4 days from today. Okay, let's record. Okay,
After 4 weeks.
Lordship, after 2 weeks.
no, after
Release.
4 weeks.
Correspondence and all that will take time, my lord. Affidavit,
Yes.
government.
Okay, but pendency of this writ petition shall not be a bar to the respondent authorities
For holding DPC, no, that's it.
to dispose the representation dated 25/8/2022, 29/9/2022, and 2/11/2022.
All right. Okay.
My please, lordship, my lord. In this matter, my lord. For widening of NH 415, my lord, this highway which is being constructed by Itanagar to Bandadeva. There was an assessment, my lord. For paying compensation to the affected people, my lord.
Yes, which,
NH 415.
let me see. There's
Lordship will find that
NH,
415. This page 19, mal, this is the notification issued in 2016, mal. Page 19. Annexure 1, page 19. Yes. Last para, my lord.
Just wait. What is your page 19? Let us see.
My lord, this one. This is the notification, my lord, for construction of NH 415. ma'am. What happened, my lord? Therefore, they wanted the compensation to be given, my lord. My lord, just clause 4, my lord. Rest, I'll leave it. 4. Compensation for land or structure will be provided to only location where the alignment is changed due to design consideration. Therefore, the Highway Division of PWD, in consultation with the Secretary Land Management and Deputy Commissioner Capital Complex, is directed to carry out the detailed survey to assess the quantum of compensation on the basis of aforementioned specification of right of way for NH 41 from Itanagar to Bandadeva. So, on the basis of this notification, Lordship,
Your land was acquired for widening.
yes. And my line comes under clause 4. It's a deviation. It doesn't fall on the route.
Under?
Under the route ROW. It doesn't come under ROW, right of way. So it comes under clause 4. It's because the road, my lord, in Karsing, sir, there's divergence. It doesn't go to earlier road. Alignment has been changed in that area. So, my lord, according to this notification, my lord, they assessed the compensation that has to be paid to the petition.
What is the area of the land which was acquired?
Lordship, this is chainage, my lord.
Chainage?
Yes.
No, the whole chainage cannot be your land.
No. Specific chainage, my lord. It's a
Specific
mention.
chainage.
Yes.
So within that chainage.
Yes.
You are the
land-
absolute owner.
Yes.
Which
Yes.
chainage?
My lord, page 25, my lord, is type copy.
Just wait.
Port, my lord, almost. Lordship, we have 4. 1, 2, 3, 4. Dibya Niyama.
What
Chainage-
is this serial number so and so? What is
This is a chainage number 521802 52230.
This is chainage.
Yes, chainage number. So right side is the calculation one of the compensation. So the total amount, the compensation we have calculated according to us, Malad, according to this, it is 50 lakhs, 58,500 rupees.
So compensation of 8,41,620 was paid to you
Malad?
for the land.
Yes. Yes. Now, Lordship, here, this is, Lordship will see right side, if you Lordship the chainage. This is the calculations for bamboo, banana tree, teak sampling, hollow sapling, teak, hollow, cocoon, jutli.
This assessment was made by
2016 with Deputy Commissioner and the Highway Authority. And this amount has been released by central government to the state government. This assessment, according to this assessment, the money is pending with the state government, Deputy Commissioner.
Yes.
Now,
Mr. Ratan, if the money is in the state exchequer, pay.
Notice may be issued. There might be some reason why this has not been paid.
Now, what happened,
Because
Madat?
There has been some re-verification after
There-
this.
Lordship, I'll just complete one more, Madat. What happened, Madat? Then we agitated it when you are assessing the compensation for standing trees, etc. Madat. Why not for the land also? Because you are taking away my land, Madat. Then they assess the land compensation also, Madat. The land compensation which they arrived at was, Lordship, that is it, Lordship will find, Madat. Page 29. Page 29. Same chainage, my Lordship. Number 1, page 29. The type of assessment, land residential. And the amount is 8 lakh.
Your precise grievance is that you have been paid for the land residential, but you have not paid for the plantation.
Yes,
You have
Malad.
not been paid for the plantation. That's all.
Yes. That already assessed and that was released by central government to the state government. That amount has not been released, Malad. We agitated for land also, Malad. We said, "Well, you pay the compensation for the land also." What they did was they paid compensation of land and they didn't pay the compensation that was released by central government, which is 58 lakhs, Malad. In other cases, they have paid land compensation and also standing trees. What they are doing here is paying the land compensation only now and withholding the compensation that was assessed in 2016. That's why our simple prayer is the release the amount which has already been paid by the central government to us. We are not seeking anything from the state government.
Heard, Mr. So-and-so. Learned counsel for the petition. Stop. By the notification dated 29/3/2016. Widening of the existing 2-lane to 4-lane dual carriageway of NH 52A
Yes.
within bracket new NH 415 from Itanagar to Bandiriwada,
Bandar Deva.
Bandar Deva,
Yes.
was proposed by the government. It is the case of the petition that the petitioner's land falls under chainage 52180 dash 52230. Of the road where the widening has been notified. It is further the case of the petitioner that the compensation has been assessed for the land belonging to the petitioner. And in terms of the assessment, the sum of rupees 841,620 has been paid as the compensation for the land acquired.
Yes, madam.
Stop. It is however the case of the petitioner that the petitioner is yet to be paid the amount of rupees 50,58,500 within bracket 55 lakhs 50 lakhs 58,500 for the plantation on the land which has been assessed by the authorities. Where's your representation?
Last, my last number. Page 33.
The stop. This is 2022.
23, Lordship.
The petitioner has submitted the representation dated 16/10/2023 to the Deputy Commissioner, Capital Complex, Itanagar, Arunachal Pradesh. For releasing the outstanding compensation amount of rupees 50,58,500. However, no action has been taken on the representation submitted by the petitioner. Being aggrieved, the petitioner is before this court. Issue notice to the respondents? Returnable.
I am for the respondent
Up to
number
4
three.
weeks. Yes,
I am for the respondent number three.
so who is for 1, 2, 1, 2, 3?
1, 2, Mr. Kamduk will be appearing now.
1, you will be appearing, Mr. Ratan?
Mr. Kamduk. D.
1 and 2.
Yes,
You will be for
for, R4.
R4.
Yes.
And you will be
Three,
for?
I am for three.
3, 4, okay.
1 and 2, we have already served notice, my lord.
Standing counsel is there. Mr. Kamduk is the standing counsel, land management.
Mr. So and so. You're standing counsel
Yes, highway,
of
highwayman,
Mr. So and so, learned standing counsel,
highway PWD.
highway and PWD. Appears for the respondent number 3 and Mr. R. Ratan. The learned additional advocate general appears for the respondent number 4. Stop. No formal notice, therefore need be issued to the respondent number 3 and 4. Stop. The learned counsel for the petitioner shall however take steps for service of for furnishing the requisite copies of the writ petition to the learned counsel for the respondent number 3 and 4 within
2 days.
within a period of 2 days from today. Insofar as respondent number 1 and 2 are concerned, the learned counsel for the petitioner shall take steps for service of notice upon the said respondents by registered post with AD within
No,
a
but we
period
have
of,
already served, my lord.
that we don't know, within a period of
2 days, my lord.
2 days from today. You are taking privately.
No, my lord.
That is not official.
No, my lord.
Within a period of
My
2
lord.
days from today.
Lordship, before filing, we have to serve copy to them, my lord. That's the procedure.
Well, I think we are not aware of that.
Standing counsel, because.
Okay, next.
Item number 6.
May it please the Lordship.
Yes.
My lord, the petitioner is aggrieved by the action of the respondent authorities in cancelling the allotment of government quarter given to her without any notice to her. Your lordship kindly at page 38.
Page
38, my lord.
38.
Yes. This is an allotment order, my lord, issued by the Director of Housing, the authority which allots quarter in the capital complex area. That was on 20th of January 2022, madam. While the petitioner was in possession pursuant to this order, I received this order at page 39. This is dated 22/1/2024. May I read, madam?
Just wait.
Complaint was received from Chief Engineer RWD by complaint letter number such and such dated 9/9/2023 and reported that government quarter number 47BB. It's a barrack, my lord, located in ESS sector, which is allotted to such and such. White order number 16 is under the unauthorized occupation of Srimati such and such. That is me. It is reported that allotment already been cancelled by the Director of Housing. On the basis of the efforts complaint and so-called notice and another notice that was issued to Srimati. However, it is reported that such name would not be traced out and therefore requested to issue fresh notice with contact number worth hearing. In light of the above facts and circumstances, the next date of hearing is hereby refixed on 13/2/2024, 1100 hours. I received this matter through the police. Accordingly, I go there and my lord, only on that day, on 13th, my lord, I received this order at page 40. Type copy, my lord, is at page 41. By this order, my lord, while the earlier allotment order was standing, the chief engineer of the Rural Works Department, he allows this to the private respondent. This is 2nd of August 2022. I was also, my lord, furnished with this order at page 43. This is by the Director of Housing. My lord, will kindly note the
This
date.
is,
My lord,
this is page 43 is cancellation order.
cancellation by the, my lord, will kindly note the allotment order is before the cancellation order, August. And I no notice nothing, my lord, before both these orders. So by
Cancellation order is to November
2022.
2022 and the allotment order is
2nd of August 2022.
to August.
Yes, my allotment is, my lord, 20 January 2022. Both these, my lord, without any notice, my lord. And relying on this, my lord, this
Cancellation
order
order.
at page 44
This
came.
cancellation order of your allotment.
Yes, my lord, no notice, nothing, my lord. And placing reliance on these two orders, my lord, this order at page 44 has been passed, requiring me to vacate the quarter within a period of 2 weeks, 13 to 2024. My lord, what I'm praying, my lord, if it comes out that the Director of Housing had no authority, then I will have to go, my lord. But it was without any notice, my lord. The difficulty I have now is, my lord, if your lordship kindly page 46.
Yes, wait.
My son is studying in class 7 in the Government Middle School, ESS sector in Itanagar. He has her examinations from 5th of March. So, my lord, at this stage, page 46 is the certificate issued by the headmistress. Type copy is at page 46A, my lord. Class 7, my lord. The examination schedule is at page 47, my lord. Forty-seven is the examination schedule. Starts from 5th of March and ends on 14th of March. So, my lord, what I'm praying for today, my lord, is let notice go, my lord. In the meantime, they will file reply. In the interim, my lord, some protection, my lord. Because the cancellation was done way back. They did not initiate any proceedings, my lord. Only now they have come up with this.
Yes.
Lordship, I'm for respondent number 3, my lord, Housing Department. So we have to take instruction in this regard. Definitely, my lord, there's some misunderstanding between us and the RWD department, my lord, in allotting the quarter.
Who is for the RWD? Yes, I am for it.
Yeah, so we'll resolve it, but
Yes, my lord. Let them file their affidavit.
Now, housing department says this quarter is still under RWD foods. So we have to hand over, unless we hand over, they cannot issue allotment.
But housing
That is my
department is
answer.
the authority, my lord, for allotting this. I mean, let them file affidavit in the meantime.
Your difficulty is that your son is having exam.
Yes, that
We dispose of the petition with the direction to
And my-
extend the order.
and my lord, they have
Nothing,
no, my lord, they have issued these orders without any notice to us, my lord.
no,
Notice to my
that
lord.
is not required.
But how can, my lord, after
The house belongs to the RWD.
My lord, that may not be correct, my lord. That may not be correct.
No, the authorities have stated that.
That is what they said. There is some confusion. Otherwise, the housing department could not have allotted it. And I have also said that.
In any case, why actually do you want to retain that house when this court is trying to give you liberty with an extended date?
My lord, that I understand, my lord. But if it comes out that it was not the RWD quarter, then the earlier quarter will have to remain, my lord.
That is not your lookout. That is not your lookout. Whether it is RWD quarter or not, that is for the interdepartmental, in the department.
That will only
You
come
are
out.
not, you are not associated with that.
Respect, my lord, that will only come out when the affidavits are filed.
The ground of
If it-
cancellation
if
of
it
each
comes out,
allotment,
my lord, on the
our
next day, my
allotment
lord, this
itself
can be
was.
disposed of.
And the housing director, knowing that the house belongs to the RWD department,
Yes.
has cancelled your allotment way back.
That's why, my lord, that was done without notice, my lord. How can they do it without, in gross violation of the principles of natural justice, my lord?
When it is wrongly allotted,
My lord, in fact, to my
we will
knowledge,
dispose.
to my understanding, my lord, there
We'll give
was,
extended date on the ground of the petitioner's son's exam.
Definitely RWD.
Till examination, that can be, that I cannot object that since
Yeah,
there
this
is.
is not.
otherwise, my lord, let them take instruction, verbal instruction, at least, my lord, what is the position, my lord? But let my learned friend also take that.
Why do you want instruction when this court is willing to extend your stay?
My lord, my thing is, my lord, if it comes out, my lord, if
It shows that you want to perpetually reside in that.
No, not perpetual. It's not a question of perpetuity, with respect, my lord. There's an allotment order in my favor. Housing department has done it. Now, if they show by some document, this unit belongs to the RWD, I will have to go, I understand that. But I have made a categorical statement
See,
that the housing department, there are
this-
4
this-
units in that barrack, my lord.
The director housing has himself admitted that this quarter belongs to the
My
RWD
lord, with
department.
great respect, my lord, I have been part of many litigations. This director housing have passed many orders that have been
Ah.
found illegal by this honorable court.
And you see your own notification, which you have annexed.
My lord. Yes.
Ah,
This only provides for the housing department, my lord. But there have been many litigations when this same.
This provides for housing
I should
department,
not say this, my lord.
and the matter should be initiated from the parent department. Matter should be initiated to actually allot you a building. The matter should be initiated from your parent department. Nothing was
No,
done.
no, my lord. Here, there is no different pools, my lord. Only the housing department is the authority who allows the quarter. Even the high court employees are allotted quarter by the housing department. And that is why I am saying, my lord, I have been part of litigations where an employee of this high court, my lord, was allotted in quarter by the same director to accommodate somebody, my lord, he cancelled it. And the high court allowed the petition. That is why I am insisting for a notice, my lord. Otherwise, I would not have.
Okay, we'll listen tomorrow. You bring one of the orders of the High Court. Let us, I am not inclined, in fact. You bring High Court's order tomorrow. Let us see. On the
Yes.
basis of that, you may get some relief.
My
Hmm.
my lord, in that case, my lord, provided no course of action be taken till tomorrow because today
No,
is the
no,
last,
tomorrow, list it again tomorrow.
today is the last day, my lord. 14 days are over.
Advise your department not to take any coercive steps.
He will.
Okay,
Of course, we will not.
The police will, I think, they will.
He can advise
Government.
for 1 day, there is nothing. Definitely, he can ask him.
no coercive action shall be taken by the state respondents till tomorrow.
Oh,
Number 9.
May my lord. My lord, standing leading counsel is absent. Matter may be listed up to 1 week.
Yes, yes.
Standing counsel has been absent. Matter may be listed up to 1 week, my lord.
Standing counsel for?
C Modi,
Petitioner,
This item?
item 9.
C Modi.
Yes, my lord.
For the petitioner?
Yes, my lord.
Yes, what is your prayer?
My lord, he is absent.
He is what? Out of.
Out of station.
Mr. So and so. Learned counsel submits that. Mr. C Modi. The learned counsel for the petitioner is out of station and therefore seeks adjournment of the case for a week. Prayer is allowed, listed accordingly. Okay.
Yes, my lord.
Item number 10.
Here, your lordship, we need some more time to file our affidavit, your lordship.
Here for the government.
Yes, your lordship.
Standing counsel,
No, your lordship.
government advocate.
Yes, your lordship.
No other respondents?
All
No
the
other,
respondents.
only government.
You are for all the respondents?
Yes, your lordship.
Okay. Mr. So and so, the learned government advocate. 6 for 2 weeks' time. to file affidavit in opposition on behalf of the state respondents. Prayer is allowed, listed accordingly. Yes.
Item number 11.
This was the item you were mentioning, ma'am?
Yes, this was the mention made by that respondent number 3 to 5, my lord. I'm appearing for petition. Here, my lord, already respondent number 1, 2, and 7. They have filed their
1, 2,
and 7.
one, 2, and 7.
Yes.
They
And
filed
3
their
to,
affidavit.
3 to 4 are represented by standing council held. They wanted to file affidavit by appearing this honorable court and seek 2 times. And the respondent number 6 is the standing council held land. They don't want to file affidavit.
3, 4.
3, 4, and
Madam,
5.
your
1,
vote?
1, 2, and 7. We have filed one.
they have
1, 2, and 7. Yes, yes. And you?
And on behalf of the standing council for health, Mr. Tabatakum.
Respondent number
3, 4, and 5.
3, 4, 5. Let's see. What about 6, 7? Who is for 6, 7?
6 is, my lord, standing council held land.
Huh.
They say that they don't want to file any affidavit.
Let them make that submission. Who is the standing council? Land management?
They come to.
The Kamduk.
Mr. So-and-so. Learned counsel makes a mention on behalf of Mr.
Tabatakum, my lord.
So-and-so. The learned counsel for the respondent number, the learned standing counsel for the respondent number 3, 4, and 5. And 6, 4, 2 weeks' time to file affidavit in opposition. Correct?
Your Lordship, I'm not aware whether the council wants to file affidavit. However, he's out of station and has just only instructed me to seek adjournment.
Lordship, 2 weeks is enough. Already they have sought for 2 more occasions.
So, ma'am, what was the last sentence? No, 6 for 2 weeks' time. On the ground that the leading counsel for the respondent number 3, 4, and 5 is out of station. Prayer is allowed, listed after 2 weeks. Stop. None appears for the respondent number 6 and 7.
7.
We have.
7.
For the respondent number 6. None appears for the respondent number 6. Comma, MS so-and-so, Leonard Government Advocate for the respondent number 1, 6, 15, 16, and 17.
My lordship, I'll be filing for 6 only.
Pardon?
For respondent number 6, I'll be filing. For DC.
You have filed?
We'll be filing.
Okay. Mr.
Ji Tarak,
The so-and-so, Leonard,
standing counsel for RWD.
standing counsel for RWD department.
Yes.
For Leonard, standing counsel for RWD department, the respondent number 2, 3, 7, and 8.
Yes.
Correct?
Yes.
And Mr. So-and-so,
Yes.
Leonard standing counsel,
Land Management Department for respondent number 4 and 5.
Land Management Department for respondent number 4 and 5. Stop. MS, new para. So-and-so, the Leonard Government Advocate submits that the affidavit in opposition filed on behalf of respondent number
15 and 17.
15 and 17 will also cover respondent number 1 and 16.
16, it won't be necessary, my lordship. State pollution code. They have served us only 2 copies, extra copies. So we have served one for DC and one for Forest Department.
So you are saying that the 15th, this will cover, if it filed by 15 will cover 16 also.
So,
The stop, the learned government advocate. Our 6 for some time to file affidavit in opposition on behalf of respondent number 6. Correct? Stop. Mr. So-and-so, Learner Standing Council, RWD Department, also 6 for some time to file affidavit in opposition. Listed after 3 weeks for enabling the Learned Council for the respondents to file the respective affidavit. Okay, marvelous.
Lordship, I filed an affidavit today.
Yes, ma'am.
I filed an affidavit from the petitioner side for the paper publication that we have filed, that we have published in the paper. And the advertisement is on the page number 7 of the newspaper.
By which order you were directed to issue this notice?
Lordship, the last order.
Last year.
Yes. 10 January, if I'm not wrong.
So in terms of this order, you have published the notice
Yes, Lordship.
by paper publication
On 10 January.
on
10 January 2024, the order was where this order we were directed for paper publication.
you had actually filed this publication on 14 January.
Yes, Lordship.
On 14.
Yes, yes.
Yes, I mean, my lord, I am entering appearance on behalf of sole respondent, my lord. In the morning, I have filed my authority, my lord. My lord,
The
yes,
summons has been issued to you.
yes, my lord. I am appearing for that, my lord. Sole respondent, my lord.
Okay.
Morning, I have filed my Okalana, my lord.
So what is to be done in the case?
Lordship.
You are appearing only today.
For sole respondent, my lord.
This is the first time you are appearing?
Yes, my lord. Well, my humble submission would be, my lord, I have no objection, my lord, for appointment of arbitrator, my lord, by the decision of the court, my lord. This is for appointment of arbitrator, my lord, by the petitioner, my lord. I have no objection, my lord. If my lord allow the application, my lord, and appoint arbitrator, my lord.
Who is to be appointed? Is there a list of arbitrators?
And my lord, there is panel of this by, there is panel of list of arbitrator by, in High Court, notified arbitrator, my lord. For the High Court, my lord. There
Of the
is
High
this,
Court.
my, yes.
Whether that panel is here,
Sorry, Lordship,
whether that panel of arbitrators,
in the High Court.
huh? You
There-
are
there may be.
supposed, how do you appoint the arbitrators?
There is a notified panel of arbitrator for the High Court, my lord. I am informed.
Yes, Mr. Tapil.
Must be available with the bench. From how retired judges who have consented.
So the consent of the arbitrator has to be obtained.
No, those who have consented, their lists are already provided.
See, sure.
If party wants to get appointed from outside the list, then they have to take the consent of the person. Otherwise, this has been notified by the high, this announced court.
Acha, this section 11(6) of Arbitration and Conciliation Act,
Oh.
1996. Let's see, what is it? Is there any agreement to appoint a consensus arbitrator? Yes,
Yes, my lord, I am informed, my lord, in agreement clause, my lord, entire between the us, my lord, is there, my lord. Agreement, arbitrator.
agreement clause, what does it say?
Lordship, there is a tender agreement in the petition.
Pardon?
In the tender document of the petition, annexure number 2, on annexure number, yes, 2, page number 15, there is a arbitration clause.
Page 15.
Page 15 is the tender document, and the condition for appointment of arbitrator is in page number 47. Page number 47, point number 37, arbitration. Paragraph 37, arbitration. All disputes between the parties to the contract, other than those for which the decision of the CWE, TFC, or any other person is by the contract, expressed to the final and binding, shall after written notice by either party to the contract to the other of them be referred to the sole arbitration of a serving officer having degree in engineering of equivalent or having passed final direct final examination of subdivision 2 of Institution of Surveyor, India. That is for if they agree for an arbitrator from the department itself.
Go to the sole arbitration of a serving officer. So whether in this list, this class of arbitrators is enumerated. If we are to go by 37,
Lordship.
then I think there should be a consensus.
Yes. The arbitrator.
And the arbitrator should be a serving officer having degree in engineering or of equivalent, or having passed final examination of subdivision 2 of Institution of Surveyor, India, recognized by the government of India. So these are the class of arbitrators who are to be appointed. So it's not as simple as saying that you have no objection. I think this recourse has to be taken too. So I think for appointment of an arbitrator, some discussion is necessary.
Madam, then may I pray that I may be allowed to take further instruction on
You have
that,
to
madam.
take instructions. Because if you say that you have no objection, then she may appoint an arbitrator afterwards. I think that will trap you.
Right.
Okay,
You take instructions. I
Right.
think it will be good.
Lordship, a date may.
Yes, we are fixing it. MS so Learned Counsel for the petitioner. And Mr.
L per me, madam. L per me.
So learned, no standing counsel, no?
No, yes, no.
Counsel for the sole respondent.
Mile.
In terms, stop, new para, in terms of the order dated 10/1/2024, passed by this court. The petitioner has taken steps for service of notice by paper publication upon the sole respondents. Stop. Mr. So-and-so, learned counsel for the sole respondent. 6 for 2 weeks' time to receive necessary instructions. Where is allowed? Listed accordingly.
Lordship, date may be fixed.
Listed. Yes, you give a date, you are supposed to receive instructions. You give a date, your convenience. Yes, ma'am.
March 25, madam.
Listed on
March
March
25.
25, holiday, my lord, it seems, my lord.
Okay. 28.
28, madam.
28. Listed
March.
on 28/3/2024. Okay.
Obviously.
I think 18 or 19.
This review petition.
Review petition.
Review petition. Yeah, Lordship, what happened, Lordship? The review petitioner, Lordship, he's a constable in IRVN, Lordship, past IRVN. There was a departmental proceeding and he was dismissed from the service, Lordship. Against that order, Lordship, the writ petition was filed before his own court, Lordship. Then that writ petition was disposed of on the past day when the motion stay itself. That is at page 49. Page 49.
49.
49. Then relevant is page 15 also.
Just wait. Page. Page 49.
Page 49.
This page starts from page 48.
It is start from page 48. Correct.
Okay, then
Then relevant is at page 50 also.
page 50.
50 also. Just I'd like to read this. Since the appeal prepared by the petitioner is a statutory appeal, this writ petition is hereby disposed of at the motion stage itself by directing the Deputy Inspector General of Police, Police Headquarters Itanagar to consider and dispose of the appeal prepared by the petitioner dated so and so against the order of dismissal from service dated so and so issued by the Commandant 3rd Airborne BHQ Sijosha, Pakistan District, Arunachal Pradesh, within a period of 45 days from the date of receipt of certified copy of this order with a speaking order. The petition shall also be heard before the speaking order is passed by the deputy so and so on the appeal. There is so and so prepared him name. Lordship, against the dismissal order, Lordship, the petitioner filed a statutory appeal, Lordship, and that appeal was pending before the authority. Therefore, this Honorable Court directed, closed this writ petition, directing the authority to consider and pass a speaking order on the appeal filed by the petitioner, Lordship. But when this, because this, it was done in motion state itself, Lordship. But when this judgment was placed before the authority, Lordship, the appeal prepared by the petitioner, it was already, Lordship, long time back, it was already considered and disposed of. And that was not placed along with the writ petition by the petitioner, Lordship. So therefore, this review, Lordship, if Lordship see the page 51, Lordship.
Just wait. In writ petition 236 of 2023, this order dated 18/5/2023 was passed. Is it correct?
It is correct.
2/36/2022.
18/5/2023 order has been passed.
The Deputy Commission to consider and dispose of the appeal preferred by the petitioner dated 2/11/20.
That is page 47 also. Page 47. Against the dismissal order lawsuit. Dismissal was done on 3/1/2022 lawsuit. Against that order, this appeal was prepared by the writ petitioner.
Where is your review petition? Review petition, okay.
Present petition is the review petition.
Review petition, yes, review petition. And where have you stated the grounds in the review petition?
Lordship, finally come to pair of 5 and 6 lawsuit.
Para 5 and 6, page.
Grounds lawsuit is start from paragraph 7 lawsuit, but even then lawsuit facts I have narrated in page 5 lawsuit, para 5 and 6 lawsuit. Page 5, paragraph 5 and 6 lawsuit, I have stated the facts of lawsuit, disposal of the appeal lawsuit.
Where is the respondent?
Lawsuit,
That dismissed constable.
step was taken lawsuit. It seems lawsuit service is awaited lawsuit.
Then you tell me, if not, I wanted to dispose of. It's no longer. So we'll await the service report.
Lawsuit, I may allowed to take fresh step because this step was taken lawsuit 12/7/2023 lawsuit. Almost lawsuit 8 months has passed lawsuit.
This respondent has not appeared even once.
No, not even once. Lawsuit.
You have not taken steps even once.
Lawsuit, it was taken lawsuit. It was taken on 12/7/2023 lawsuit.
12/7.
2023.
2022. Ten 7/2023.
Lawsuit.
10/7/2023.
Yes, lawsuit. Here, in here, as for my request lawsuit, 12/7/2023.
No, 10/7/2023.
Right.
You were directed to take steps.
Step. The order was passed on 10/7/2023. That's correct, lawsuit.
So you take fresh steps once again.
Lawsuit.
Okay. If not, I thought we will dispose it. Mr. S. Tapin, the learned senior government advocate, shall take fresh steps for service of notice upon the sole respondent by registered post with AD as well as by usual process within a period of
2 days.
2 days from today and file affidavit to that effect. Okay. Listed after
2 weeks.
2 weeks.
All right.
Item number 19.
Yes, ma'am.
Your Lordship, I have instruction to withdraw the case.
Steps procedural. Yes, ma'am.
I have the instruction to withdraw the case.
You're the learned counsel for the petitioner,
Petitioner.
MS so and so. The learned counsel for the petitioner submits that she has instructions to withdraw the petition. Stop. The contempt petition is accordingly closed as withdraw. Okay.
Item number 20.
May I please, Your Lordship? So in this matter, service upon the respondent number 4 and 5 has been completed, Lordship.
This is a service upon respondent number 4 and 5.
4 and 5, Lordship.
To 1 and 3.
Office note shows that Mr. T.T. Tara and his associates have filed Bakalatnama on behalf of respondent number 4 and 5.
Lordship. In this matter, Lordship, the respondents, they have yet to file their affidavit also, Lordship.
Yes, Your Lordship. We need some more time, Your Lordship, for filing our counter affidavit. At least 3 week time may be given, Your Lordship.
You are waiting for him to prompt you.
No, Your Lordship. He was submitting, Your Lordship, the council of the petition.
You are the counsel for the respondent number
1 in 3, Your Lordship.
1 and 3.
Yes, Your Lordship.
1 and 3. And learned counsel, you are the.
Yes, I have for respondent number 2.
You are for respondent number
2.
2. 4 and 5. There's a Mr. T.T. Tara has filed. Will it be necessary for you to file affidavit?
Yes, in this case, also, I'll be filing also.
MS. So and so, the learned government advocate for the respondent number 1 and 3. And Mr. So and so, the learned standing council, land management for the respondent number 2, 6 for 3 weeks time to file their respective affidavit. Prayer is allowed, listed accordingly. Stop. Although office note dated 16/11/2023 reflects that Mr. T.T. Tara, learned advocate, and his associates have filed Bakalatnama on behalf of respondent number 4 and 5. There is no representation on behalf of respondent number 4 and 5, listed after 3 weeks.
Oblige, Your Lordship.
Big obligations.
Item number 21.
What about 20? Oh,
Be pleased, Your Lordship.
yes.
I'm the petitioner matter pertaining to my VRS. So I have taken steps upon respondent number 1 and 2.
When?
This is in the month of, just after filing the petition.
May I, Your Lordship? Lordship, I'm appearing for respondent number 2.
2.
Lordship. Copy has been served this morning, so I need some time for filing an affidavit.
Who is for 1, 3, 4? Ma'am,
Here, I'm for respondent number 1 and 4, Your Lordship. We are not the necessary party, Your
they
Lordship.
are not necessary.
Yes, we have already communicated to the
Two,
department, Your Lordship.
two
are
is,
represented.
two is necessary.
Yes.
Okay. The government advocate,
This is Chief Electoral Officer.
chief electoral.
Chief Electoral Officer, yes.
You are the
Yes,
engaged counsel.
Yes. So my affidavit will be required.
Yes. MS so and so. The learned counsel for the respondent number 2 submits that she has been furnished with the copy of the writ petition only today.
Today, this
Only
morning.
today. And therefore 3 weeks time to file affidavit in opposition. Prayer is allowed, listed after 3 weeks.
Lodge, obliged.
My lord, here I am appearing for respondent number 1. We need some time for filing our affidavit. And 3 weeks time may be granted also.
You are for respondent number
1.
who is for 2 and 3, ma'am?
Yes, Your Lordship. Here, I'm for respondent number 2,
Hmm.
Your Lordship.
Who is for 3?
3, Mr. Kato should be,
Mr. Kato,
Yes.
he is. Yes. Will it be necessary for you, ma'am, to file affidavit?
I'm for Deputy Commissioner, yes, Your Lordship.
Deputy Commissioner,
it will be required also from both the state
from
and.
both,
Yes.
Mr. So and so, the Learned Standing Council for the land management. And MS so and so, the learned government advocate for the respondent number 2. 6 for 3 weeks time to file their respective affidavit in opposition. Prayer is allowed, listed after 3 weeks. Stop. There is no representation on behalf of respondent number 3. Right.